Ascent Audio, a division of Recorded Books, presents Tech Monopoly, the MIT Press Essential Knowledge Series by Herbert Hovenkamp, narrated by Tristan Morris. Publisher's Note: in this audio edition, you will hear references to figures present in the print and ebook formats of the book. Series Forward. The MIT Press Essential Knowledge Series offers accessible, concise, beautifully produced books on topics of current interest. Written by leading thinkers, the books in this series deliver expert overviews of subjects that range from the cultural and the historical to the scientific and the technical. In today's era of instant information gratification, we have ready access to opinions, rationalizations, and superficial descriptions. Much harder to come by is the foundational knowledge that informs a principled understanding of the world. Essential knowledge books fill that need, synthesizing specialized subject matter for non-specialists and engaging critical topics through fundamentals. Each of these compact volumes offers listeners a point of access to complex ideas. Preface: Antitrust and Big Tech. The subject of this book affects everyone, often in ways that people do not realize. Our lives are shaped by big tech. Even the vanishingly small number of people who have never used a computer or cellular phone are affected by tech products and services, including television and other media, or by family members who use them. Most Americans deal every day with at least one of the 5 largest tech companies: Amazon, Alphabet, formerly Google, Apple, Meta, formerly Facebook, or Microsoft. All are among the 10 largest firms in the world, but the term big tech applies to many others, including Uber, Tesla, eBay, Samsung, Adobe, Oracle, IBM, Texas Instruments, and Intuit. Others, including Intel, Qualcomm, AMD, Micron, and TSMC, Taiwan Semiconductor, deal mainly with other business firms. Not to be forgotten are large media or social networking companies whose products are heavily digital, including Netflix, Disney, Viacom, Comcast, MSNBC, Fox, Spotify, Twitter, and TikTok. Finally, are financial services firms that operate on digital platforms, including Fidelity, Schwab, PayPal, Visa, American Express, and many others. Virtually every firm today uses tech in some way, so identifying tech firms by use is not helpful. Rather, a tech firm is one that either develops digital technology or uses it as an important part of its production or distribution. Some firms, such as Spotify, sell digital content exclusively. Others, such as Amazon, Apple, or Texas Instruments, sell a mixture of digital and traditional tactile content. For example, Amazon streams music and movies, but also sells toasters, bicycles, and wrenches. It will either stream you a movie or sell it to you on DVD. Others, such as Uber, sell non-digital services but operate on a digital network for coordinating rides. The term monopoly almost always refers to products, not to firms. Only a few of the products sold by these firms are monopolies. Likely examples are Google Search, which controls more than 90% of customer search on personal computers and mobile devices. Amazon controls nearly 70% of ebooks, although ebooks are only 20% of the overall book market. Microsoft Windows is the operating system for more than 70% of desktop and laptop computers, but Microsoft has a much smaller share for tablets, and its market share for smartphones is less than 1%. The market is dominated by Alphabet's Android and Apple's iPhone. Meta, Facebook, may or may not be a dominant firm, depending on which firms are included as competitors. Netflix is very large, but it streams programming in competition with Amazon Prime, Disney+, Hulu, Apple TV, Max, formerly HBO+, and others. In most cases, size is a poor measure of market dominance. Most firms sell multiple products. Amazon in particular sells 12 million of them. That explains why its overall size is very large, while its share of individual products is often quite small. Importantly, you as a customer are typically looking for a single product. The question for you is the number of realistically available alternatives for your search. For example, if you want to buy groceries, the fact that Amazon's grocery share is 2.5% gives a much better reading of the extent of the competition than does the fact that it is the largest online retailer. There may be situations in which size is more important, but one needs to be careful. In most cases, market share of a particular product tells you much more about competitive alternatives than does the absolute size of the seller. Tech markets have some features that distinguish them from old economy markets. For competition policy, these features pull in different directions. First, much of their output is digital. This means that the cost of selling one additional unit, such as one additional copy of an e-book or a streamed video, is very low. Second, digital output is non-rivalrous, which means that the sale of one unit does not reduce the amount that is left over. You can stream Taylor Swift on Spotify as much as you want without reducing the amount available to others. For successful products, non-rivalrous digital output can make firms larger because there are few limits on the firm's capacity to produce more. Third, tech firms are often organized as networks, in which firms interconnect in order to share information or intellectual property, or to engage in operations that involve many participants. One example is blanket licensing of copyrighted music. ASCAP, the American Society of Composers, Authors, and Publishers, for example, has some 875,000 owner members who collectively control over 16 million digital musical works. Copyright owners grant ASCAP non-exclusive licenses, which it relicenses as a bundle to radio stations or distributors such as Spotify, which then relicense them to subscribers. Spotify alone had 489 million listeners in 2023. With blanket licensing, you can subscribe to a music streaming service and have immediate access to this entire library. This market could not exist if each artist had to license her songs individually to listeners. Other networks of competitors involve the cross-licensing of patents for shared technology, such as is used in cell phones or driverless cars. Still others are the old economy networks of teams that make up professional and amateur athletics. Ours is a world of networks, many of which are privately owned and operated. While we benefit greatly from them, they can also do anti-competitive things. For example, in 2021, the Supreme Court applied Section 1 of the Sherman Antitrust Act against an agreement among NCAA colleges to limit the compensation of student athletes. Network effects can make networks more valuable as the number of participants is larger. For example, a dating site such as Match.com or a ride-hailing site such as Uber becomes more attractive as it grows. As a rider, you want access to as many drivers as possible, and as a driver, you are drawn to sites with more potential riders. Indirect network effects refer to the increased value on one side, e.g., riders, as the number on the other side, drivers, increases. The gold standard in networks is the phone system, where everyone in the system can talk to everyone else. A dominated network is one that is controlled by a single firm, such as Uber or the Apple operating system. But networks can also be competitive, such as the telephone system, email system, or sports leagues in the non-digital world. These do not have a dominant firm, but rather many members of various sizes. They typically act both as collaborators in the operation of a network and as competitors with one another for your business. For example, when you set up an email account, you have a competitive choice among Gmail, Outlook, Yahoo, and many others. Nevertheless, these firms also collaborate to ensure interoperability. Another feature of networks is that they are often two-sided markets. That means that they often obtain users and revenue from two or more sides. For example, a magazine, whether digital or traditional, gets revenue from both subscribers and advertisers. Too high a subscription price and it will lose readers, and then it will also lose advertisers. But too low a subscription price and it may need to sell excessive amounts of advertising to survive. As a result, it engages in participation balancing to find the right distribution. A ride-sharing app like Uber may have to adjust its fares by the minute, with higher rush hour prices to bring in enough drivers to satisfy the number of riders, and lower prices during off hours. Some two-sided markets are completely free on one side. That is true of Facebook and Google's search technologies, but also of older technologies, such as over-the-air radio and television. Collectively, big tech firms have produced economic growth about 3 times greater than the growth rate of the economy as a whole. They have educated workforces and produce outsized growth rates in the job market. Firms in these markets also innovate much more than the economy as a whole. Indeed, in recent years, the 10 firms that obtained the most patents were all tech companies. New entry into tech markets is relatively common, and even the largest tech firms appear to be competing aggressively with each other. On the buying side, consumers often have a wider variety of choices. If you are unhappy with Walmart's toaster selection, you can exit the store and drive somewhere else. If you have the same experience on Amazon, you can switch with a mouse click. Information is usually more readily available on the internet, and comparison shopping is often easier. These factors lead one to wonder whether an antitrust policy of targeting big tech, as reflected in some journalistic writing and proposed legislation, is a good idea. Offsetting this competition, which helps consumers, big tech firms also engage in practices that have legitimately aroused antitrust concern. They are involved in many mergers. The networks that occur so frequently in tech markets often require agreements among competitors, something that can arouse the suspicion of antitrust law enforcers. Tech firms have also displaced many firms that were dedicated to older technologies or methods of doing business. For example, the rise of Amazon has been a brutal experience for Main Street retailers. Netflix and other video streamers have been devastating for the DVD business and traditional movie theaters. Uber and Lyft have caused serious damage to the traditional taxicab industry. The digital camera killed the film camera, and today the smartphone camera is killing the dedicated digital camera. Firms that lose out in market battles, perhaps because their business methods or technology is obsolete, may continue to have influence in political institutions. To that extent, the political process may lead to misguided antitrust enforcement. Chapter 1 of this book gives an introduction to the history, capabilities, and limits of antitrust regulations. Chapter 2 discusses the problem that is sometimes characterized by the press as bigness. Should antitrust law focus on large firms, or should it be instead concerned with high prices in consumer markets, low innovation, or harm to labor markets? Chapter 3 focuses more narrowly on the activities of technology companies themselves. What are the unique promises and threats to competition that they present? A closely related question is how much should the problems be addressed by antitrust law, or when should we turn to other areas of law, which are frequently more specific? Finally, Chapter 4 examines the difficult problem of remedies. Once we have decided that Meta, Facebook, or Amazon have been behaving anti-competitively, what should we do about that? Should we break them up? If so, how? Or are there less disruptive or more effective ways of dealing with the problem? While we should condemn anti-competitive conduct, we should also hesitate to break up big tech firms without understanding the consequences. Painting a pretty picture is not an important goal of this book. Antitrust law can be complicated and messy. It sharply divides people by politics and ideology. Some of its answers depend on assumptions that are not universally held. Producing economically and socially acceptable solutions is hard. As with so many complex policy areas, it contains a core of principles that tend to produce widespread agreement, but also some principles on both edges that are more controversial. 1. Introduction. The Antitrust Laws. A Thumbnail History. The United States antitrust laws grew out of social and economic turbulence around the turn of the 20th century. In 1890, Congress passed the Sherman Antitrust Act, and President Benjamin Harrison, a Republican, signed it. The Clayton Antitrust Act was signed by President Woodrow Wilson, a Democrat, in 1914. We sometimes speak of this period as the birth of industrial America. It witnessed the dramatic rise of large firms, fueled mainly by a variety of new technologies that operated on a much larger scale than previous firms had known. Another fact was the equally dramatic rise of the labor movement. driven both by immigration and by the movement of people from rural self-employment to the factory. American economic growth during this period was significant, but the benefits were uneven. During the late 19th century, the distribution of wealth became very lopsided, more than at any other time except for the present. Small entrepreneurs, farmers, and laborers were severely injured. Popular writers placed the blame squarely on large firms. In his 1901 novel The Octopus, A Story of California, the progressive Frank Norris presented a fictional California railroad as an octopus, its tentacles strangling all of California's agriculture and politics. Ida Tarbell adopted that metaphor in her 1904 History of the Standard Oil Company. That same year, Puck, an American humor magazine, printed its famous Standard Oil octopus cartoon, entitled Next. The beast's tentacles extended ominously over American institutions, encircling even the Capitol. See Figure 1, which can be found in the print and e-book versions of this book. The octopus metaphor was brilliant. It captured not only size, but also the creature's expansion beyond its core, establishing control in all places where power could be maliciously exerted. The sentient core was the octopus's body, while the mindless tentacles were its unlimited reach. Although this rhetoric was immensely popular, no antitrust decision ever broke up a firm simply because it was big. Indeed, early antitrust decisions involving dominant firms such as Standard Oil were obsessed with anti-competitive conduct, such as buying up rivals and shutting them down, predatory pricing, exclusive contracts, secret rebates, patent abuses, or excessive litigation. The law of monopoly evolved into rules that required a combination of market dominance and bad conduct. The first section of the Sherman Antitrust Act condemned agreements in restraint of trade, which were understood to be agreements that restricted output and thus led to higher prices. These included price fixing, but also market division agreements, which were agreements eliminating competition between firms, and boycotts. Section 1 was also the country's first merger law, applied in the 1904 Northern Securities case against a large railroad merger. Section 1 does not reach the conduct of a single firm acting alone. For that, Section 2 of the Sherman Antitrust Act makes it unlawful to monopolize a market. Historically, a monopoly was an exclusive right granted by the government. The original British case of monopolies, 1602, was a legal challenge to an exclusive right that Queen Elizabeth I conferred on a favored courtier to import playing cards. Another example of a government-created exclusive right was a patent or copyright. By contrast, the term monopolize in the Sherman Act referred to firms that dominated markets through their own conduct. That sent courts searching for business practices that could unlawfully monopolize a market. Congress believed that no entity should be convicted of monopolization simply because its product was better than anyone else's, but beyond that, agreement stopped. The statute also authorized the Justice Department to enforce the act, as well as private plaintiffs to sue and obtain treble damages if they succeeded. Finally, Section 8 of the Sherman Antitrust Act declared that a corporation is a single person, creating an important dividing line between Sections 1 and 2. A firm and its employees, or even a firm and its subsidiaries, are treated as one person. For example, both Google Search and the Android operating system for cellular phones are owned by Alphabet. For antitrust purposes, an agreement among them is a unilateral act, and it does not result in the formation of a cartel. In general, actions against single firms are much harder and more costly to bring than actions against cartels or collaborations. Congress was not happy with the way the Supreme Court interpreted the Sherman Act. To be sure, it condemned price-fixing agreements and produced big victories in 1911 against Standard Oil and American Tobacco. The court was too tolerant of patent practices, however, and it used the Sherman Act aggressively against labor strikes. There were also doubts about whether mergers were treated severely enough, and whether standards for anti-competitive conduct were sufficiently clear. All three political parties in the 1912 election, Republicans, Democrats, and Theodore Roosevelt's breakaway progressive, or Bull Moose Party, advocated additional antitrust legislation. The Democrats won and responded in 1914 by enacting the wide-ranging Clayton Antitrust Act. Section 2 of that act condemned a form of predatory pricing that was believed to explain how Standard Oil had destroyed smaller rivals. Standard charged very low prices in a targeted area, financed by higher prices in areas where it already had a monopoly. Section 3 of the Clayton Act prohibited anti-competitive exclusive dealing and tying, and specifically targeted patent practices. One practice that disturbed Congress was a patent owner's refusal to sell a patented product unless the buyer purchased some complementary product as well, thereby extending the monopoly beyond the scope of the patent. The Supreme Court had approved such practices under the Sherman Act, refusing to condemn office equipment maker A.B. Dick for requiring purchasers of its patented copy machine to buy its unpatented ink, stencils, and paper. Soon after the Clayton Act was passed, the Supreme Court changed course in the motion picture patents case discussed momentarily. Section 6 of the Clayton Act was intended to immunize labor from the antitrust laws, but its exemption was interpreted very narrowly until it was further expanded during the New Deal era. Finally, Section 7 of the Clayton Act contained an expanded merger provision. Congress also passed the Federal Trade Commission, FTC Act, which created an administrative process for antitrust enforcement and authorized the newly created FTC to pursue unfair methods of competition. Protection of consumers was the ultimate goal, and the FTC's masthead to this day reads Protecting America's Consumers. Ever since, the civil antitrust laws have been enforced by the Justice Department's Antitrust Division and the FTC, as well as by private parties. Only the Justice Department can bring criminal actions. The FTC has the additional power to challenge practices that may not be antitrust violations, but have similar effect. Today, we have a patchwork of antitrust laws passed by both the federal government and the states, which have their own antitrust laws. Federal antitrust law is the same across the country, but state rules vary from one state to another. The Attorney General of each state is also authorized to bring federal antitrust actions. Today, joint enforcement actions are common, brought by the federal government and as many states as wish to participate. Big antitrust actions against Microsoft, Meta, Alphabet, and Amazon have been of this kind. The scope of antitrust. Economic regulation in the United States comes from many places. Utilities are regulated by federal and state agencies. Telecommunications, electronic media, and much of the Internet are regulated by the Federal Communications Commission, FCC. Energy is regulated by the Federal Energy Regulatory Commission, FERC. Corporate securities, banking, and finance are regulated by their own specialized agencies. Antitrust law is not limited to a particular industry. The antitrust laws regulate commerce, which covers all commercial activity. This leads to some complex questions about who controls what. Answering them is beyond the scope of this book, but 2 points are important. The first is that antitrust law generally reaches any commercial activity unless it has been preempted by a different regulatory agency. For example, the Federal Aviation Administration preemptively regulates the licensing of aircraft and pilots, air traffic, and safety, as well as many aspects of airport operations. It does not regulate ticket pricing or airline mergers. Power over those lies with the antitrust laws. We sometimes say that antitrust law is the residual regulator, or the system in charge of competition beyond the reach of other regulatory provisions. A second point is that not every economic problem is an antitrust problem. The popular press is often confused about this. Firms may have environmentally harmful practices. As a result of tax law or other policy, wealth may be concentrated in the hands of a very few. Businesses may tolerate too much discrimination or harassment among their employees. They may enable the users of their products to make untruthful political comments or suppress the political views of others. They may sell dangerous and defective products or be careless with user information. None of these things is ordinarily an antitrust issue, however. That does not mean that the legal system cannot control them, but rather that the source of control lies elsewhere. The temptation is often strong to make antitrust law the regulator of the entire economy, because the antitrust laws are very general and breathtakingly short. In 2 lines, the first section of the Sherman Act prohibits contracts in restraint of trade. The second section prohibits those who monopolize or attempt to monopolize, never defining these terms. If we let our imaginations go, they can be made to cover nearly everything. The problems with such expansive readings are manifold. First, antitrust law is complicated enough if it just sticks to the historical meanings of competitive monopoly. Throwing in additional concerns, such as politics, wealth distribution, or environmental degradation, would make it less predictable and create many conflicts with other legal rules. Second, broad interpretations can easily become a way of avoiding the democratic process by getting judges to do something that Congress did not do itself. For example, someone who believes that Congress has not adequately regulated harmful water pollution may urge the courts to do it through application of the antitrust laws. But the antitrust laws never mention environmental concerns and contain no metric for evaluating them. Another important limitation of the antitrust laws is that its concerns are fundamentally economic. Although the text of the laws is clear on this point, this has actually been a contentious issue. The basic questions are whether antitrust law should incorporate some rules about fairness, justice, or morality that might make the world a better place. One important point here is the same as was made earlier. We have other laws that are much more explicit about these issues, as well as agencies that have power over them. What conduct violates the antitrust laws? While antitrust law requires proof of anti-competitive conduct, the descriptions in the antitrust statutes are very general. Decades of court decisions have filled important gaps. Further, conduct is often ambiguous. It might be anti-competitive, but it might also be either harmless or beneficial. Competitors in particular are likely to make exaggerated claims about anti-competitive practices. For example, they might complain about anti-competitive standard setting when in fact they simply flunked a perfectly reasonable standard, or they may claim predatory pricing against a rival with lower costs. On the other hand, antitrust defendants often make unsupportable claims about efficiencies or other beneficial effects of their conduct. One of antitrust law's most difficult tasks is sorting these out. Restraints of trade, horizontal and vertical. Section 1 of the Sherman Act condemns agreements in restraint of trade. That language had a widely understood meaning prior to the antitrust laws, as conduct that 1. Results from an agreement, and 2. Reduces the volume of commercial exchange. That is largely the way we continue to use it today. Restraints that limit market output tend to drive prices higher. As fewer goods are supplied, customers bid higher prices for them. The Sherman Act says nothing about the relationship among the parties to an agreement. Important competitive differences exist, however, between horizontal agreements among competitors and vertical agreements between sellers and buyers. Both can make the resulting entity bigger, but in different ways. Horizontal agreements instantly give the new entity a larger market share. For example, if 4 out of 5 competitors, each of which has a 20% market share, should collude, their effective share increases to 80%. This could give consumers fewer competitive choices. It could also enable the firms acting together to reduce market output, thereby reducing jobs, and charge a higher price or suppress wages. While a vertical agreement makes an entity bigger in the absolute sense as well, it does not result in a larger market share. If a 30% manufacturer and a 20% retailer should merge or form an exclusive agreement, their shares would still be 30% in manufacturing and 20% in retailing. The principal economic effect of vertical coordination is lower costs, a point that lawyers realized even before economists expressed it. An in-house transfer is usually cheaper than a market transaction, and the firms may coordinate their activities beneficially in other ways. The result of lower costs is higher output, which increases buying power for consumers and typically results in more jobs. To be sure, one cannot ignore the possibility that vertical integration can cause the exclusion of rivals or other harms, but the antitrust presumption is generally more favorable toward vertical as opposed to horizontal agreements. The most troublesome horizontal agreement is price fixing, or the activity of a simple cartel whose members agree to reduce their output, leading to higher prices. Managing output is typically the most difficult part of operating a cartel. Charging a higher price is easy, but agreeing to an output reduction when the price is highly profitable is hard. Cartels often fall apart because members cheat by surreptitiously selling more than their cartel allotment. Collusion is what...
Sample complete. Ready to continue?